Not doing it. Thank you.
Bunch. Warren Wells is leaving.
Oh, all right.
I told my husband after last week's committee about the committee pockets.
Yeah.
Because it really made me laugh. He's like, it's talked about it in multiple committees, it's great.
Good morning, everyone. It does appear that we are all in our places with bright, shiny faces up here. It is time for us to get commercial. Madam Clerk, would you please take the roll? Everybody log in. We'll let these two members of the herd that are traveling a few paces behind get logged in before we take the roll. By the way, we have some styluses up here, and let me say, my big old fat fingers work better with the stylus than they do with my fingertips. So if anybody has those at their disposal, I encourage you to use them. All right. Madam Clerk, would you take the roll?
Mr. Chairman, you have 19 members present. You have a quorum.
Thank you so much. I'll have to admit, by the way, welcome to the highest rated internet committee in the Tennessee General Assembly. And I'd encourage you all, give us 5 stars on your rating if you enjoy what you see here today. Today is March 5th, Wednesday. This is the House Commerce Full Committee. And we're going to do a little bit of housekeeping before we take personal orders. Everybody be thinking if you have any personal orders. Mainly what we're going to do from a housekeeping standpoint is we are going to roll bill number 3, which I'm carrying to the hill so we can get folks in and out on time today. It's a busy season here. Folks got to get up and go present bills in other places, and we're very understanding of that. So first off, are there any personal orders today before we get started? Yes, Representative Lynn.
Do I just push that? Thank you, Mr. Chairman. You know, you have pointed out in past committee meetings this new voting system. It seems a little like we don't realize when it's time to vote. And it feels weird. It feels really weird. So I brought you a few things just as a suggestion. You don't have to do it, but I just thought maybe we would look at these things. So here's that. So just some suggestions, just if you want to take them out and show the members, see if there's anything they like. I don't know.
I guess we could.
That's a little
When
happy
it's time to
bell.
ring,
It's
when it's time to vote.
little
All right.
little happy bell.
And this, we have an easy button here. Oh, it says time to vote. Oh.
I don't know if you recognize the voice.
Oh,
And I don't know that.
there we go.
Is that good?
It's
I don't
time to
know.
vote.
I don't know.
Well, here's what
I don't know.
You know what, Representative Lynn, I certainly appreciate the spirit in which that was offered. What we've taken up in banking, which was actually very exhilarating the other day in banking subcommittee, is we said aye as we pressed the green button. It felt like we'd harken back to the old days. Kind of exhilarating and freeing. So if that's what you want to do, if you want to verbalize your vote while we cast it electronically, feel free. We love all and serve all here. Thank you. Wow. Representative Lynn gets the gold star for today.
I tried.
All right. First, so if there's no personal orders at this time, we're going to get into our agenda. And first up is an appointment to the Tennessee Public Utility Commission. And I see Chairman Sapicki over there because I believe the person that he's nominating is indeed a constituent.
Thank you, Mr. Chairman and members. Good morning, everybody. First of all, I get to present you a reappointment of another great mind from Murray County, so I'm very proud to be able to do that. I object to that statement right there. Glad nobody could hear that. John High is asking for reappointment here. Commissioner High attended grammar school in a two-room schoolhouse and graduated from Columbia Central High School in Columbia, Tennessee. At that time, there were several smokestack industries in Murray County that provided jobs for summer employment. These jobs, along with some scholarships, paid for Commissioner High's college education. Commissioner High graduated from the University of Tennessee College of Pharmacy in 1969 and was drafted into the U.S. Army the following year. His pharmacy training enabled him to work as a pharmacist at Walter Reed Army Medical Center, which he described as an invaluable experience. After an honorable discharge from the Army, Commissioner High and a business partner opened their own drugstore and ran it for 10 years before selling it. Commissioner High transitioned from the world of pharmacy to the world of finance, beginning work for the venerable J.C. Bradford investment firm in 1984, when I graduated high school, advising clients about their investments. After the sale of J.C. Bradford in the year 2000, John went to work for investment firm Stevens Incorporated out of Little Rock, Arkansas. John eventually retired from Stevens in 2015 to spend more time with his family and friends, although he still works a few hours a week in the Care Zone Pharmacy in Nashville. John and his wife, Trish, have one son, one daughter-in-law, one grandson, AJ, and one granddog named Luna. I present John High to you for reappointment, Mr. Chairman.
Thank you, Chairman Sapicki. Do we have any questions for Commissioner High at this point in time? Seeing none, here in Commerce, we do exhaustive research into our appointees. Yes, Representative Hardaway showed up in time to get your first question fired off today. It's good to have you here.
It's good to be here, sir. This is really where my week begins. Are we going to be able to hear from the commission? Oh, excellent. That answers my question, sir.
Thank you. What I was getting into when I saw Representative Hardaway's hand is that Chairman Sapicki didn't touch on this, but Commissioner High is a first-generation immigrant. He and his family escaped Germany in World War II and came to this country and settled as a refugee, and his settlement brought them to Murray County, his family to Murray County. And so as a small child, he was uprooted and brought here and has had quite an esteemed career, which shows that our country is made richer by properly vetted legal immigration. And so we appreciate all you do to serve Murray County. We appreciate everything that you do to serve the state of Tennessee. And you have the floor, sir, if you have any brief remarks, or if you just want to say good morning. It's good to have you here.
Well, thank you very much. This country is, we were so glad and blessed to come here. My father loved it. I love it. The people of Murray County were just fantastic to us. And thank you very much for the opportunity to serve you.
Thank you, sir. Chairman Moon.
Thank you, Mr. Chairman. Question on the resolution.
Thank you, sir. Seeing no objections, we will honor that question. Seeing no objections, we'll honor that call for question. All those in favor of the reappointment of John High to the Tennessee Public Utility Commission, please signify by saying aye and pressing the green button. Aye. See, you got to admit it feels good, doesn't it? All righty, Madam Clerk, if anyone wants to change their vote, please do so. But if not, Madam Clerk, would you tally the votes?
Mr. Chairman, you have 22 ayes, 0 noes.
Thank you, Mr. High. We're honored by your service and we appreciate you being with us today. You're approved. Speaker Marsh, you're recognized.
Thank you, Mr. Chairman. I want the committee to welcome Bedford leadership here today from Bedford County and Shelbyville, youth leadership and adult leadership led by our own Warren Wells. If you all please stand and let us welcome you.
Shout out to Bedford County this morning. All right, moving on. We're coming up on item 2, which is House Bill 683, presented by Leader Lamberth. We've got a motion and a second. Sir, you're in proper posture. Please share with us what you're doing today.
Thank you, Mr. Chairman, members of the committee. There is an amendment coded 004376 that makes the bill. Mr. Chairman, maybe if y'all would please put that on the bill, I would truly appreciate it.
Oh, we'd be honored to.
Thank you, Mr. Chairman.
Leader Lamberth, honored to. All those, we've got a motion and second on all those in favor of attaching Amendment 4376 to House Bill 683. Please signify by saying aye. Any opposed? No. The amendment's attached, sir.
Thank you, Mr. Chairman, members of the committee. This issue came up with talking to some of the best defense experts in the state. We have only one armed guard license at this juncture. It's one level. That's it. So whether you're extraordinarily trained in former law enforcement, former military, if you train every single year, you don't get any additional certification beyond just the regular armed guard license. This creates an enhanced armed guard license where those individuals would be prior military, prior law enforcement, extensive training, so that if someone is hiring an armed guard, they know that that individual is well trained and can actually defend their person or property. And this could be for schools, it could be for businesses, it could be for individuals, but they know that they are getting an upper echelon, well-trained individual. And Mr. Chairman, that is what the bill does, and I stand ready for questions.
Thank you, Leader. And from my understanding of this, going over the bill, it seems as if the primary, with regards to, except for the enhanced background and training, the main thing that this will do will allow someone to escalate the amount of protection that they've got on their premises, primarily by these people being able to carry long guns. And so this would allow for stricter security forces who are properly trained in the use of those weapons. Is that a fair statement, Mr. Leader?
Thank you, Mr. Chairman. It does do that. Armed guards are currently allowed to carry shotguns, but they are not required to qualify on those shotguns. So this bill would allow them to still continue to carry shotguns or rifles. It adds that aspect in there, but they would have to qualify on those on a regular basis in order to be able to do so. They are required to qualify on the pistols currently, but the standard is relatively low for the armed guards. This would again increase that for both pistols, shotguns, or rifles.
Well, thank you, sir. This sounds like a great idea. I appreciate the fact that we're offering enhanced training for those situations to where security does need to be escalated for whatever purpose, whether it be the activity that's going on at a site or whether there's been threats mentioned. So I do appreciate this. You seem to be filling in a void. Leader Camper, you're recognized.
Thank you, Mr. Chairman. Thank you, Leader, for the bill. Do you see that, or maybe did this come out of some need for sometimes there are companies that have a high level of security needs with respect to their product, their inventions, or just the nature of their business, that by having these higher level of armed guards, it gives them and their employees a sense of security. You don't have this false sense of security. You have somebody that you feel is well trained to protect not only the employees, but the product, the service, or whatever it is that they're offering.
Leader Lamberth.
Thank you, Madam Leader. That's exactly what this is. I mean, be it a school or a business or an individual, I mean, in talking with these security companies that are already out there, there's no way to separate the wheat from the chaff. So it doesn't matter if you're just barely able to qualify as an armed guard or if you're the absolute cream of the crop. Right now, there's no distinction. This creates that distinction.
Thank you, Mr. Chairman. Thank you for the bill.
All righty. Thank you. Any more questions for the Leader? Speaker Marsh, you're recognized.
Thank you, Mr. Chairman. Do they have to pay money to get this license? Is it quite expensive, or what's the process?
Leader Lamberth.
Yes, there's a fee for the licensure that is similar to what is already there for the armed guard. It's a little bit more, but I mean, some of that will be promulgated by rules. But it is not an unobtainable type license, but there would be a fee for it.
Thank you.
Any other questions? Seeing none, we will call the question on House Bill 683 to send it to government operations as it is currently amended. All those in favor signify by saying aye and pressing the green button. All right, Madam Clerk, tally the votes for us, please.
Mr. Chairman, you have 22 ayes, 0 noes.
Thank you so much. Leader Lamberth, you are off to GovOps. We appreciate the bill.
Thank you, Mr. Chairman, members of the committee. Thank y'all.
All right, members, I want to go back and clarify something. House Joint Resolution, the nomination of John Hyde to TPUC, that proceeds on to calendar and rules from here. To calendar and rules for the nomination on House Joint Resolution 242. And House Bill 683 also passed. We're going to roll, as I said, we're going to roll 3 to the heel. Chairman Rudder, come on down. Chairman Rudder, come on down. We're ready to hear House Bill 871. We've got a motion and a second. Well, let's do a little housekeeping here. You have an amendment. Is it traveling with this bill? Amendment number 3950?
It is.
All right. We need to go ahead and adopt 3950 and get it on there. All those in favor of placing Amendment 1, which is drafting code 3950 to House Bill 871, please signify by saying aye. Aye. Any opposed, no. We're amended. Now then, tell us about your bill, Chairman Rudder.
I'll be glad to. This bill would allow residential condo developers to use a portion of the buyer's deposit for construction cost. Their deposit may only be used for actual costs detailed in this legislation. Buyers will be explicitly informed in the purchase contract that a portion of the deposit may be used for construction costs. To ensure full transparency, buyers must provide written acknowledgement by acknowledging this provision in the contract. A deposit made up to 10% shall be held in escrow account. A developer may only access these funds with a surety bond or a letter of credit. A portion of the deposit exceeding 10% may be placed in a separate escrow account and used strictly for actual cost of construction. Current law requires that this deposit, the buyer's deposit, be held in escrow and only released at closing. There is no provision in current law that would allow any portion of the buyer's deposit to be allowed for construction cost. This bill will accelerate construction timelines, allowing developers access to a portion of their deposits that help finance construction, reducing delays and risk of incompletion and expediting projected completion. By enabling developers to to move forward and approve projects more efficiently, this bill will help address the growing demand for housing in Tennessee and affordability thereof. And I ask for your support on this bill.
Thank you, Madam Chairman. Nice use of the word thereof in a presentation. Well done, well done. All right, let me feed this back. Let me feed this back to you and see if we've got it. Okay. So in the past, people put a deposit down on a condo. The person building the condo places those funds in an escrow account, but if you can't have access to them, then basically they do not function as equity in your deal. This is for you to achieve financing for the rest of your project. What this does is allow the developer access to those funds, but the consumer's protected because they have placed an instrument of surety, whether it be a bond or a letter of credit, to protect those deposits for the consumers. Do I have that correct?
You have that correct.
All right, sounds good. Anybody have any questions for our bill sponsor? Representative Hardaway, you're recognized.
Thank you, Chairman. And thank you, sponsor. On the participation by the mortgagor, is there any need for approval by the mortgagor for the use of this money towards the construction?
Bill sponsor.
This is a contract between the developer and the buyer. There would be no issue with them. That would be with the developer, with the mortgage company.
All right, so as long,
Hold on a second. Representative Hardaway, I think I know what you're asking, and I think I may,
Okay.
I think I can perhaps answer this question. What this bill is doing is affecting the relationship between the buyer and the builder / developer. The relationship that you're speaking to when you talk about, it could either be a mortgagee, final mortgagee, or it could be a loan officer, or well, just through a standard lender, whether it be a bank or whoever else is going to be financing that. This does not affect that relationship. What this is doing is affecting the buyer who's depositing the funds with the builder, and then the relationship between whoever's lending money on this project is a separate relationship that is not affected by what we're doing here. But what it does do is this gives access to those funds so that whenever I, as a developer, go present my project to a lender, I show them that I have equity in the project that I can access. And so, but the consumer, again, is protected by either the bond or the letter of credit. So it does affect that relationship with the lender, but what we're doing does not affect legally any requirements of the lender and that builder developer. Does that scratch your itch on that one?
it got some of it.
Okay.
And just for the record, I used to own a mortgage company. But what I want to make sure is that the agreement that the buyer has with the mortgagor is that if there's language that's necessary in that agreement, that their equity is represented by cash investment as opposed to the actual construction, added construction from that cash. That's what I'm trying to get to, Mr. Chairman.
Well, it depends there. Excuse me, Madam Chairman, let me answer this for Representative Hardaway. Because basically what happens is whenever I talk things through, I gain a better understanding of what all these fancy words say. In a case of a project like this, there can be two separate loans. One would be a loan to a buyer, or they could be a cash buyer. This doesn't, again, this bill does not contemplate any type of lending relationship. But if it was the overall construction loan that the builder developer was seeking, then they would be this would be really integral to that relationship between that lender and the builder developer. By the time it gets to the purchaser who's put the deposit down, seeking permanent financing for that condo unit, that's a separate relationship with someone else that, yes, this 10%, their equity in their unit, which again comes back to them at closing, would be represented as true equity, because by then either the project is cashed out and sales start, or has a certificate of occupancy issued and sales begin, but that 10% will come back into their account, into their credit, which the mortgage company who they're using to buy, and again, they don't have to borrow money. Folks who used to formerly own mortgage companies may have so much cash on hand that they don't need a loan. But in that case that they do, folks like me who have to borrow money to purchase nice things, that relationship between the lender and the purchaser they would know that 10% was being returned to them at completion of the unit, and that surety would go away. So that's, if that helps, if that answers your question, or if not, if you got any other questions of the sponsor.
No, on both accounts.
All right, thank you. Does anybody else have any other questions? Oh, Representative Burkhart, I missed you down there. You're recognized.
Thank you, Mr. Chairman. I had a problem with the wording of this too. The word deposit has got me confused. I think the word down payment would be better, because I think they're using this deposit as a down payment and I think if you substitute down payment for deposit, I think you understand the bill better. But anyway, that's the way I understand it. And when I talk to the people who are actually who come to my office and talk to me about it, they agreed it's basically a down payment. So anyway, thank you.
Thank you, sir. And I think this is one of those bills to where the subcommittee, we chewed on this for a while. I know Representative Barrett also contributed to the conversation on it that actually helped me understand what we were doing a lot better. And so I think that we're good to go to vote this. Representative Hardaway.
Thank you, Chairman. No, I think I was sponsored some support in some way, shape, or form. And initially, this is a deposit, but the conversion is what changes it when it becomes used for the construction purposes. So it starts out as a deposit, and then it's converted. So thank you, Mr. Chairman.
Leader Camper, is your hand up?
Thank you, Mr. Chairman. It was up. My question was, I'm trying to get in my head, if I am a developer and I'm developing these condominiums and there are 50 condominiums and 50 people put their deposit down or down payment down, then I, as a developer, will have access to all 50 of these different deposits or down payments that I can then begin to use for the construction of the development, as well as use that to be able to go to the bank and say, I'm developing this and I have access to these 50 accounts to help with the development of the property. Is that an accurate statement?
That is
Sponsor.
correct. You have it down.
Okay.
Leader Camper.
Thank you, Mr. Chairman. And is there some maximum amount that I can access, up to 50% of the deposit? Or would that just depend on each of the different 50 people and their agreement, how much of my deposit you can access in order to build this development? Or is it just the same, everybody have up to a certain amount?
Madam Sponsor.
There's 10% of the deposit that you can access.
Okay, so just, thank you,
Leader Camper.
thank you, Mr. Okay, so just up to 10% of what the individual buyer deposited that they would have access to.
And then we move on to that's the 10%, that's the surety bond. And then that protects the buyer. And then.
Pardon me, Madam Sponsor. I think we have we've had a misspoke that I want to get into the record. Okay. Leader Camper, they can access 100% of that 10% deposit. That's why this bill sponsor said that it was up to 10%, I believe is what you intended,
Right.
sponsor. And that 100% of that 10%, then I think you were going on is covered, is indemnified, or there's a surety that's
Surety
been
bond.
placed up that covers that 10% in case everything just goes haywire. Well, then there's somebody that's on the line to get that 10% money returned back to that depositor. And if you need to embellish on that, Madam Sponsor, feel free.
You're doing a great job, and I appreciate it.
Thank you, Mr. Chairman. Thank you, sponsor.
Thank you. Chairman Clemens, I saw your hand up. Or were you just saying hello and good morning this morning?
Well, I was doing both, Mr. Chairman. Thank you. I've been wrestling with this one, and the surety is the issue, and how difficult it's going to be for these potential purchasers who've paid this down payment and whose project goes belly up after 10% of their down payment has been used, and how difficult it's going to be for them to get their funds back. Can you speak to that at all, sponsor?
Chairman Rutter.
I really don't I don't understand what you're saying. I don't understand. You're saying that you're worried about the buyer being at risk for signing the agreement with the developer to be able to use.
No. So if they're paying this money and 10% of it's being used on actual cost, and when you sign people up for that, you could be using that, those condominium purchasers for your financing. I mean, you could be using that to get your financing, as we discussed last week in the subcommittee. So if 10% of your money is going in and it's already been spent on actual cost, whatever that may be, the protection of the purchaser is my main concern here. So that project goes belly up halfway through construction or whatever, things go south in development deals or construction projects. What is the recourse? And I know you got the surety in here to protect them, but how difficult is it going to be for them to get that money back, to claw back that money that has already been spent? That's my question. And what's that process look like, and what additional costs will they incur to try to do that, whether it's court system or otherwise? That's a concern of mine.
Madam Sponsor, I can take this one. I think that frankly, having a surety on the line for it is far better and far secures that deposit much more so than them having to depend upon in fraught economic times, which has led to whatever failure this is, to be able to find an individual to get them to cut you a check. I think this actually is better for the consumer and gives them better access to those funds because it's going to be indemnified or by a company that is in the business, surety business. And so it should make it better for the consumer, more so than them having to find the guy who's really upset about his dream going south. And so that would be someone who has lived through that Great Depression they put on us back in 2008 and still have scars from it. I can tell you that when you start dealing with institutions as opposed to individuals, you as a consumer have more certainty and more protection. That's one man's opinion. Chairman Clemens.
Thank you, Mr. Chairman. And then my follow-up to that is, well, I've already lost my train of thought. You did such a good job answering that question, Mr. Chairman. Well, I forget. Never
Okay, that's fine. Deputy Speaker Zachary.
Thank you, Mr. Chairman. Question on the bill.
All right. Question's been called without objections. Let's vote on House Bill 871 as amended, going to calendar and rules. All those in favor signify your aye by either verbalizing it or punching that green button. I'm going to say aye. All right. Anybody want to change their votes? Madam Clerk, would you tally those for us?
Mr. Chairman, you have 19 ayes, 4 noes.
All righty. Your bill passes, Chairman Rutter, and you're off to calendar and rules.
Thank you, Mr. Chairman and committee.
And I appreciate your indulgence. I have to talk myself through these things every now and then.
I appreciate you. Thank you.
Mhm. Next on our calendar is House Bill 713 by our much missed former member of the Commerce Committee, an alumni, so to speak, Representative Alexander. We've got a motion and a second on House Bill 713. Could you talk to us about which amendments you would like for us to put on?
Absolutely. But first, I want to say how much I miss not being with you guys. So thank you. It's good to be back in your presence. The bill is traveling with an amendment from subcommittee, but I would like to withdraw that amendment and put amendment with drafting code 4359 on the bill.
All righty. Thank you. Could you discern or describe to us the difference between those two amendments, what we're doing?
So the 4359 amendment, the new amendment, it does 3 things. It cleans up the definition sections in the portion of the bill. It delays the effective date from January 1, 2026, and it adds a hold harmless provision to the section relative to the abandonment. I would like to thank Representative Clemens for his questions during subcommittee about the hold harmless provision, because it prompted me to narrow that language.
All righty. Thank you. Unless anybody's got an issue with it, let's swap out amendment 4359, amendment number 2 for amendment number 1, which is coded 4023. All those in favor of doing such, say aye. Any opposed? All righty. Representative Alexander, you are in the posture you desire to be in. If you could describe your bill to us.
Okay. This bill does multiple things, and it's basically a cleanup for the cemetery. Department of Commerce and Insurance requested changes relative to the definitions and effective dates, so we made those changes. And it does clean up multiple things that has been needed to be cleaned up in the cemetery, Tennessee Cemetery Association for some time. The bill does not do anything with nonprofits, church families. They are all, none of those church cemeteries, none of those nonprofit cemeteries. This is only for the cemeteries that the state regulates. The difference in the numbers is 30,000 plus in like family cemeteries, church cemeteries, to maybe 197 in the cemeteries that the state regulates. I understand that there is another amendment on the bill, and I am willing, I would like to hear from the sponsor of that amendment also.
Well, Representative Alexander, I think I'm going to grant that request.
Thank you.
What we're going to do now is Amendment 3 has been proposed by a committee member. Representative Hale has taken issue with a few items in your bill and has offered an amendment for our consideration. So what I'd like to do is hear an explanation of those issues that he's concerned about. The amendment number is 4464, is it not, Representative?
That's correct.
All righty. Talk to us about amendment number 3. Yes.
Second.
You are in proper posture, sir.
Okay. The amendment, I've addressed an issue with this portion of the piece of legislation from the very beginning. And what it does, and I'm thinking totally of consumers and of families. And I'll give you, for instance, if you go and purchase anything that you purchase in relation to funeral home, cemetery, you can prepay. You can, but the cemetery base fee, you can pay for grave digging, you can pay for all of those things in pre-need form, but the base fee, if you go and buy, just say my dad, which he died at 39, and we buy 10 graves, we're going to go on and put his marker down, but we've got these other 9 graves that we're not going to do anything with right now. So if we're not doing anything with those, there's no way we can go ahead and pay the base fee because we don't know if it's going to be a single monument, if it's going to be a double monument or whatever. And so by doing that, if we remove those caps that was put in place for a reason, they've been there for several years as a guideline, they're inflationary, they do increase. So by doing so, we are, I think, hurting the consumer by totally removing those and not leaving those in place as they are. And so what the amendment says is if you had bought graves previously, then you would be able to be grandfathered in under the current statute. But if you go to the cemetery today and buy 10 graves, then you know that from this date going forward, there is no cap and the sky's the limit or whatever. But it protects those that bought those graves previously under the guidelines as they currently are in statute. So that's basically what the bill, what the amendment does. So any other questions?
All right, committee, what we've got is, you consider this to be an unfriendly amendment. Is that correct, sponsor?
Yes, only because, not because I'm not friendly with Chairman Hale there. I highly respect him. He owns a cemetery. I mean, you don't own a cemetery. He owns a funeral home. He also owns a monument company. I only owned a funeral home, so his knowledge is far greater than mine when it comes to cemeteries. So I highly respect his opinion. But the Cemetery Association of Tennessee is opposed to this amendment because having 2 sets of rates, one for plots purchased before the effective date and one for after will create confusion for cemeteries and families. In addition, no southern state sets a cap on installation rates, and monument dealers are not regulated or restricted on their charges. But I look forward to, I'm at the will of the committee, and look forward to having more discussions on this. If we can make this bill better, I'm all for doing that, sir.
Thank you, ma'am. And this is one of those cases where this amendment came in late yesterday. Some might say it was a Hail Mary.
Yeah. Oh, that's good.
So this is where I'm going to exercise my jurisdiction as the benevolent dictator. I find two people that I have a great deal of affection and respect for, both with experience in the industry. I am going to, without objection, I'm going to roll this a week and have them go and solve this problem between the two of them and come back with a bill that everybody can feel good about, or at least we're not picking a winner and loser at this stage. If they, thank you, sir, if they can't get there, then we will pick winners and losers, because that's what we do. But we're gonna resist at this moment and try to get them back. So without objection, this bill is rolled 1 week.
Thank you, committee. Thank you, Chairman.
Next up, House Bill 561. Representative Capley. Sir, you have a motion and a second. You are recognized.
Thank you. Good morning, Your Benevolence. Proud to be back before you again. I've got another high power, high octane piece of legislation coming out of the Comptroller's office. This bill makes government work better by improving utility systems' abilities to issue emergency operating loans, streamlining TBOR's contested case hearing authority, and enhancing the efficiency of bond issuance. And with that, sir, I am ready for questions.
Thank you, sir. I believe this was showed a little bit of a gap we've got in our fence during the hurricane. Came out that we needed another vehicle by which to take care of utility districts with their emergency repairs. And also, thanks to Chairman Boyd, we heard from TBOR last week and also streamlines their case hearing. So we appreciate you bringing this on behalf of the Comptroller. Anybody, any questions for this bill sponsor? Seeing none, let's call. Oh, Representative Hardaway.
Thank you, sponsor, and for the bill, and thank you, Chairman, for the answer to the question I'm about to ask you. Does this impact MLG&W?
Thank you, sir. It should not. This has to do with water utility districts as opposed to municipal-owned utilities.
All right. Thank you. Thank you, sponsor.
Chairman Powers.
Thank you, Mr. Chairman. Question on the bill.
We've got a question on the bill. All those in favor of passing House Bill 561 on to calendar rules, please signify by saying aye or punching the green button. No, and punching the green button. Aye. If anybody wants to change their vote, do so now. If not, Madam Clerk, please tally the votes.
Mr. Chairman, you have 21 ayes, 0 noes.
Thank you. Sir, you are off to calendar and rules.
Thank you.
House Bill 378 by Representative McCalman. We got a motion and a second. It's traveling with an amendment, amendment number 3848. Is that correct, sir?
That is correct, Mr. Chairman.
All right, let's get that applied. Got a motion. Do we hear a second on the amendment? Second on the amendment. All those in favor of attaching amendment 3848 to House Bill 378, please indicate by saying aye. That was rather lackluster, but there was enough to attach the amendment. Aye. Let your eyes be eyes. Come on. All right, Representative McCalman, tell us what we're doing.
Good morning, Mr. Chairman. Always nice to see your shining face. And good morning, members. Members, what House Bill 378 does is allow for reserve police officers and sheriffs to serve in the capacity as a security guard without having to go to security guard school. Reserve officers and deputies by the state are required 128 hours of training At present, that training is left up to the agency. However, they are required to complete the same 40 hours of in-service as full-time officers the first year and subsequent years. This training involves 8 hours of firearms, 2 hours of emergency vehicle operations, mental illnesses, DUIs, child abuse, and sexual abuse as well. With the amendment on it, this bill does not exempt reserve officers, auxiliary officers from any other portion of this chapter. It just applies to them in the capacity of security guards. With that, I stand ready for questions and renew my motion.
Any questions for the sponsor? Any questions for the sponsor? Seeing none, we're going to vote this. All those in favor of sending House Bill 378 on to calendar and rules as amended, please signify by saying aye. Aye. Please press the green button as well. Old habits die hard. All right. Everybody wants to change their vote. Representative Hemmer, you got in. All right. Good deal. Madam Clerk, would you please tally the votes?
Mr. Chairman, you have 21 ayes, 0 noes.
All righty. Sir, you are off to calendar and rules as amended.
Thank you, Mr. Chairman and committee.
All right. Thanks. Next up, making a fashionable entrance to the committee. A motion and a second on House Bill 1384 by Representative Harris. Representative Harris, you have an amendment, I see.
I do have an amendment, Chair.
Would that be drafting code 4370?
That is correct.
All right, let's get it attached. I've got a motion and a second on the amendment. All those in favor signify by saying aye. Aye. Oh, good. That's better. The amendment is attached. Tell us what we're doing here, Representative Harris.
Thank you, Chair, and thank you, committee. House Bill 1384 is considered the Pay Stub Protection Act, which would require an employer to provide a statement to an employee or the employer's payday regarding their pay wages. So just making sure that everyone gets a pay stub. We had some really good discussion about this in the previous committee. And so I brought an amendment that would answer 2 of those issues that we discussed. Part of the amendment that adds to this bill would require that an employee shall provide to an employee of the employer in a written or electronic state or another form of access to the employee a statement of the employee's earnings and deductions for each pay period within 20 days of the employee's pay date. So once the employee is the pay date actually takes place, they still have 20 additional days to be able to provide them actual documentation, which is really good as far as the length, because then it allows them to still be able to meet any, if I need to go get a new car, or if I need documentation to go rent a home or whatnot, I still have a good window. In addition to that, what the original bill said was that once an employee reaches out to the department, there's an additional 10 days, which that was already in the original language. And the last piece of it just adds that an individual or private cause of action does not arise from the violation, so that there's not an uplifting of additional lawsuits from this. So that is the amendment to the bill. But the gist of the bill is just to simply make sure that everyone gets paycheck stubs.
All right. Thank you, sir. Let me say to you, Representative Harris, thank you for working with the business community that's reached out to you with questions. And I'd like to let the committee know I was interested in trying to figure out whether or not Commerce and Insurance may have been a better home for complaints than Department of Labor. But Commerce and Insurance came and talked to me, and Labor is prepared to do this, and they felt like it'd be the better home. So we're going to leave that portion stayed as it was. Questions for the sponsor? I saw Chairman Lafferty.
Thank you, Mr. Chairman. Thank you, sponsor. I just wanted to ask, on these pay stubs, will the amount of taxes withheld by the federal government be highlighted in fire engine red?
If you so choose to as an employer.
Bill sponsor.
Thank you, Chair. If you so choose to as an employer, you're more than welcome to.
Thank you, sponsor. Thank you.
I know that when my children got their first paycheck, it might as well have been in fire engine red. That was the first thing they wanted to know is, who is this FICA person? Deputy Speaker Marsh. Speaker Pro Tem Marsh.
Thank you, Mr. Chairman. And we talked about this in the subcommittee. I appreciate you putting this amendment on here. But my question is, as I brought up in the subcommittee, I was with a guy who paid a worker with a check last week, and it didn't have a stub. And I think what my question is it mandated that they give them a stub within 20 days, or if the worker asks for a stub, they must provide a stub?
Bill sponsor.
Thank you, Chair. And give me just one second. I just want to make sure I
I
read
think
it
I know the
properly.
answer to that.
Okay, if I'll let the chair properly answer that. Then.
Deputy Speaker Marsh, it's upon request.
Upon request. That's good. That's what I wanted to see.
No, they are. Wait, it says they shall provide it, but then if the employee asks, it has to be, if they don't and the employee requests, but effectively it's a 20-day window that they've got to get that information to the employee. Speaker Marsh.
But what is happening here and what can happen, I think, is that a lot of these people are paid by a check from a small company, and they're basically not giving them a stub. But if they ask for one, they will give them one. So if this is mandating, then a lot of people are going to have to change the way they're doing business. They're going to have to come up with a stub whether the employee wants one or not. Right?
Sponsor.
That would be correct. So if they ask for one, they would be required to provide one within 20 days. If they do not provide one within 20 days, the employee has the ability and the right to then at that point reach out to the department and have the department mitigate it. And then there's an additional 10-day window that they would have to respond to providing a pay stub at that point. So there's about 30 days in whole.
Speaker Marsh.
But what if the employee does not ask for a stub and they don't need a stub?
Right. If they
Bill
don't
sponsor.
Thank you, Chair. If they don't ask for a stub and they reach out to the department and ask for a stub, the department will then connect them with that employer, and that employer would then be notified to be able to provide a stub. There's no penalties at that point. They're still being just notified. It's similar to if a person applied for unemployment, we're going to request paycheck stubs for unemployment. They have a time period that they have to be able to provide that document. So if they don't go directly to their employer at that time and they come straight to the department, there's a window in which they have so that the department isn't just getting overwhelmed with a lot of people asking for paycheck stubs, that they've been rerouted back to work with them. I deal with this on the EEOC side too. On the EEOC side, most times EEOC will say, hey, let's see how we can work with the actual employer first before we actually step forward. So it's the same way. They have a time window to be able to provide that.
Speaker Marsh.
But my question is, what if the employee does not need a stub and they don't care about getting a stub? Is this going to put the employer under some kind of risk because they didn't provide the stub? The guy didn't want a stub and the employer didn't give him a stub. So he's breaking the law by not giving the stub, the way I understand this now. If it's mandated, I just don't think that's really right.
Mr. Sponsor, you like hanging out with us, don't you?
I do. I enjoy this.
All right. Well, hey, here's what I'm going to suggest in this, because the people must have transparency. Laborers need to have transparency with their employer over how their pay is calculated, whether they're a 1099 or they're a person who withholding should be taken from. But I understand what Speaker Marsh's issue is. I would hope that you'd be willing for us to roll you for a week, and let's place this to where to address Speaker Marsh's concern that they have to provide it within a 20-day period upon request of the employee. And if that's the case, I think then everybody is covered.
Yep.
And they can have the documentation they need for whatever reason. And he's hit on something, and I had overlooked that portion that where it was mandatory. I thought it was only on request that they had that 20-day window. So if you'd be willing to you've been very cooperative with us, and we're going to lean on that cooperation a little bit more if we could. But Chairman Moon down here is about to, he's about to strain himself, raising his hand. Chairman Moon, what have you got to share with us?
While we're taking care of those issues, can we address independent contractors, part-time employees at the same time? Because independent contractors aren't employees. So I don't know if it's in the if it's in the bill, it define how they define employee.
We're going to go out of session right quick, and we're going to have a little bit of reading on this. Stand by, bill sponsor. Sometimes the people's business can get a little bit messy, especially with me at the helm, but we're going to get some input from legal services.
Levin Middleton, Office of Legal Services. So to Chairman Moon's point, employee is defined in the bill as a natural person who performs services for an employer for valuable consideration. I think at this time, the bill doesn't distinguish between, we have a list in statute of determining whether someone's an employee or an independent contractor, and it doesn't make that distinction at this time. I did also want to clarify for Speaker Pro Tem Marsh, employers, as the bill's written, are required to provide the statement within 20 days. However, if they don't provide the statement, the bill specifically says that an employee that doesn't receive it may submit a complaint. So if you have a situation where the employer doesn't provide it, maybe they spoke to the employee and the employee said, I don't, want that or need that, then the employee doesn't, submit a complaint to the department. From my understanding, nothing would happen at that point. But that is how the bill is currently written, that they're required to provide them. If they don't, the employee can request one. They get an extra 10 days to provide it in addition to the 20 days. And then if the employee still wants that statement, then they can choose, if they wish, to submit a complaint to the department, and then the department can step in if needed. So that's how it's currently structured.
Any questions for legal? Speaker Marsh.
Well, in your opinion, do we need to change this where it basically doesn't put the employer at risk of being in trouble because they didn't provide it? You're saying that they must, and then you're saying that they don't have to at the same time. So I think it maybe needs some clarification some kind of way.
I think in terms of how the committee would like to handle that, that's more of a policy decision. You are correct that the initial part of the bill says they're required to provide it, but then in terms of what triggers the enforcement mechanism through the department, that's whether the employee submits a complaint or not. So if an employee doesn't submit a complaint.
All right, we're back in session. I think we can get this cleared up. I think the issue that your bill is addressing is one of value and that we need to take up, but I also want to make sure that it's clear. I think a one sentence amendment will probably take care of what we need. We like seeing your smiling face here anyway, Representative Harris. So without any objections, I'm going to roll House Bill 1384 1 week.
Thank you, Chair. Thank you, committee.
All right, I'm going to jump out of line here. Chairman Boyd's got a conflict, so I'm going to ask that we call up House Bill 1143 so we can get him on to his next appointment. All right, you're recognized, Chairman Boyd.
Thank you, Mr. Chairman. Committee members, House Bill 1143 simply combines two separate lists in code into one. There's a clean list, a renewable list. It combines it to the clean and renewable list and adds the word green to it. Mr. Chairman, I'll take any questions.
Thank you, sir. Seeing no question. Oh, Representative Clemens, Chairman Clemens.
Thank you, Mr. Chairman. I just want to clarify. We just passed a bill last year or recently that created a list of sources of clean energy or green energy or renewable energy, right? Where we decided what would meet those qualifications.
Chairman Boyd.
Thank you, Mr. Chairman. Yeah, we did that two or 3 years ago. Yeah, and this just simply it's kind of a cleanup bill. It merges the list and adds the word green to it. It doesn't add any more energy sources.
Chairman Clemens.
Thank you, Mr. Chairman. And so it's, am I correct in that this bill would say if they do any of those things on that list, then they automatically meet the requirements of that political subdivision?
Chairman Boyd.
Thank you, Mr. Chairman. The bill that was passed several years ago did that. This simply merges two lists together.
Chairman Clemens.
Okay, I'm trying to reconcile the summary of this bill and the fiscal note with what we're doing. Thank you, Mr. Chairman.
Okay. Oh, Chairman Powers. You're recognized.
Thank you, Mr. Chairman. Question on the bill.
We've got a question on the bill. Without objection, we are going to vote it. All those in favor of sending House Bill 1143 to calendar and rules, please signify by pressing the green button. And if you want to, say aye. Aye. So everyone voted. Madam Chairman, would you record the votes, please?
Mr. Chairman, you have 18 ayes, 0 noes.
Thank you very much. House Bill 1143 is on to calendar and rules. Getting back to our, the order of our agenda, Speaker Pro Tem Marsh, House Bill 421, sir. We got a motion and a second. You're recognized.
Thank you, Mr. Chairman. I do have a amendment 3624.
Let's get that attached before we talk about this. We got a motion and a second. All those in favor say aye. Aye. You're attached.
Currently, this is brought to us by the utility districts. Currently, utility officials are required to get 12 hours of continuing education within the first year of serving on a utility board and an additional 12 hours within 3 years. What this bill does, they still have to get the first 12, but it reduces the second 12 down to 6 hours to minimize its redundancy in the training. The second part of the bill, right now, if a commissioner on the board does not take this training, he is kicked off the board. So this second part allows this, and if they're kicked off the board, they're kicked off for a lifetime. The second part gives them a way to get back on the board. And what they have to do is take the training and then they have to go meet before the board, and they may require commissioner to complete the training prior to reinstatement. And there's other things that they must do before they're reinstated. Basically, that's the two things it does.
All righty. Thank you, sir. Do we have any questions for the sponsor? Seeing none, we're going to vote on House Bill 421 as amended, sending it on to finance. All those in favor, please signify by saying aye or punching the green button. Aye. Madam Clerk, it is indeed tally time.
Mr. Chairman, you have 16 ayes, 0 noes.
All righty. Thank you. House, you are on to finance, Mr. Speaker. Next up, Representative Lynn with House Bill 412. Motion and second. You're in proper posture. Please, Representative Lynn,
Okay,
share with
thank
us.
you. Thank you, Mr. Chairman. This bill is at the request of the Propane Gas Association, and it deletes an obsolete reference in the code, and that reference is to the National Propane Gas Association, and it substitutes state or national associations representing the liquefied petroleum industry. It has to do with their education, and the National Propane Gas Association doesn't offer education anymore, so this is opening it up to other associations that also represent the liquefied petroleum industry.
Thank you, ma'am, and thank you for anticipating my question. And do we have any questions for the sponsor? Seeing none, we're going to vote to send House Bill 1154 on to calendar and rules. Excuse me, I read the wrong bill. House Bill 412 on to calendar and rules. All those in favor, press the green button and say aye if you want to. Aye.
Aye. I want to hear the bell.
Madam Clerk,
Funny.
tally time.
Mr. Chairman, you have 16 ayes, 0 noes.
You are off to calendar and rules. How about this, Representative Lynn?
All right, I like it.
You're next up with House Bill 1154.
Thank you, Mr. Chairman. This bill has to do with the self-storage business, and self-storage business is a regulated business in Tennessee since about 1980. And over time, an owner may need to revise a lease agreement. And what this bill permits is a facility owner, after notice to the tenant, to treat the continued use of the space as acceptance of the revision of the lease agreement. The second thing this bill does is it permits a facility owner to evict a tenant who is still paying rent, but is violating the law or rules of the facility in some way, such as by living in the unit. Right now, the facility owner would have to go to court and to get that person evicted. It's a very long, expensive process. And if that tenant is violating the rules, it would allow the owner to evict them.
All right. Self-storage business, what's the storage wars? Sure, we've all seen it. Yep. Anybody have any questions for our sponsor, Leader Camper?
Thank you, Mr. Chairman. Representative Lynn, I think I asked this question in subcommittee, but for the record, if there is a perception that someone has broken the law, they put out, evicted, and the reality is that they didn't, is there any appeals process? How can a person go back and would the property have been put out or seized, or what would happen in a situation like that?
Bill
This,
sponsor.
oh, thank you, Mr. Chairman. This would be the facility owner saying, hey, you're living here, you can't do that, you have to leave. And I guess the appeal would be the person saying, I'm sorry, I fell asleep, I'm not really living here or whatever. So this is outside of a court process. And so the appeal would be simply from the renter to the owner. And hopefully reasonable minds will prevail.
Leader
Okay.
Camper?
Thank you,
Follow
Mr.
up?
Chairman. Thank you, Mr.
Okay.
Chairman.
Chairman Powers.
Thank you, Mr. Chairman, and to the sponsor. Does this mean that I'm going to have to move out of my storage unit? And if so, how long do I have to do that?
Well, it has,
Bill sponsor.
it hasn't passed. This bill has not passed, so you're probably good for the rest of session. But if you're talking about a storage unit at home, you talk to your wife.
Okay. Thank you.
Thank you, Mr. Chairman.
Any other questions? I tell you, I'm always amazed at the storage business. We probably sharing too much information, but I realized that I'd paid one year I went and I'd paid like $1,500 for my storage unit. And then I went and decided that I was going to see what I could do to get rid of it. And I realized that the combined aggregate value of everything I had in the storage unit was less than $1,500. So I had a business decision to make. All right, let's vote. Let's vote on House Bill 1154 after my moment of introspection. All those in favor of sending it to Calendar and Rules, please signify by saying aye. Aye. And we must also press the green button. Madam Clerk, give us the tally.
Mr. Chairman, you have 17 ayes, 0 noes.
All right. Representative Lynn, you're on Calendar and Rules. We've cleaned up House Bill 12, so now we have come to the main event on today's calendar. We have appreciate everybody hanging through with us. It's been a long calendar. We're going to finish up with House Bill 1342 by yours truly, and so I'm going to pass the gavel down to the very capable Vice Chairman Bricken.
We have a motion second on House Bill 1342. It's item 3 on the agenda. The bill's in proper position. Would the sponsor declare to explain his bill?
Yes, thank you, Mr. Chairman. The House Bill 1342 deals with folks who improperly file a UCC lien against public officials. Apparently, that's a way that folks demonstrate their displeasure by nefariously trying to mess up someone's credit by filing improper UCC liens against public officials. And what this bill does is it establishes the process by which the Secretary of State's office, who records UCC liens, can very effectively and quickly get those off of people's credit records so they don't destroy their credit whenever it's filed in such a manner. So that is what this bill does.
Hearing the explanation, any questions on the bill? Seeing none, let's call the question. All in favor of the bill, please vote on the board.
Aye.
And say aye. Will the clerk record the vote?
Mr. Chairman, you have 17 ayes, 0 noes.
The bill passes, and I see no fiscal note, so I assume it goes on to calendar and rules. Oh, judiciary. All right. It goes to Judiciary Committee. All right. There you go.
Thank you, sir. Folks, that wraps up today's business. I did see a group of bright, shiny faces back there that came in to join us. Can someone tell us where you folks are from? You don't look like the normal folks that sit out here and listen to our work. Yes, ma'am. Shout out to Weekly County. Thank you for being here. Anybody else have any personal orders? Seeing none, we are going to be adjourned.